Typically, once you have reached an agreement over a car accident settlement, your claim will come to an end. However, there are a few times when the car accident case will continue so that a lawsuit takes place. This will depend on how many defendants there are and how many of them you have settled with. It will also depend on the settlement's terms. Please note that it's almost impossible to file a lawsuit with each defendant that you have settled with when it's too late. If you decide to settle a claim and you sign a release of liability, it is too late to do anything else. This is the case even if you decide to refuse the money. It also means that a lawsuit is over even if you had started to make progress with it. Setting the settlement aside. The only way for you to reopen any case once you have agreed to a settlement is if you are unable to agree with the insurance company or the defense attorney. When a plaintiff has reached a personal injury settlement, they have to sign a release so that the defendant or their insurance company can pay the settlement. While most car accident cases tend to be quite straightforward, there can be a dispute over the release and the terms associated with it. If the dispute is quite serious, the plaintiff or the claimant can back out of the settlement. However, the procedures surrounding this can depend on whether the plaintiff decides to settle the case before they have filed the lawsuit or after. If a settlement was reached before the lawsuit. If you decided to settle the claim before a lawsuit was filed and without a lawyer, and you do not want to sign the release, you will need to hire a lawyer. This is because the insurance adjuster is uniquely to change their mind based on what you have said, which means you will not be able to take the claim any further. However, with a lawyer, you could. If you do decide to hire a lawyer, the insurance adjuster may still refuse to change their mind. If this is the case, you will be given two choices. 1. Sign the release and accept the settlement. 2. File a lawsuit and hope a judge will let you change the release. If you choose to settle a lawsuit. If you choose to settle a lawsuit, your lawyer and the defendant's attorney will argue over the release. The good news is the differences are usually resolved, which means your lawyer may ask you to sign a release. If your lawyer and the defendant's attorney are unable to agree, then the dispute will be submitted to the judge. This means that it will be up to the judge to make a decision on the case. The judge could order you to sign the settlement release or order it to be changed. The judge could also cancel the settlement and order all parties to carry on with the lawsuit. If your lawyer gave you bad advice. If you think your lawyer gave you some bad advice about settling your case, you will not be able to file a lawsuit or withdraw from the settlement. This means the case is over and the only thing you can do is to file a case against the lawyer. However, you will have to show that they mishandled your case in such a way that they committed legal malpractice, which is very hard to do. If there is more than one defendant. When it comes to making a claim against more than one defendant, you should be aware that making a claim against one of them does not prevent you from making a claim against another. However, you will need to make sure that you are careful when you read any release, as some may say that signing it means you give up all potential claims that may have been caused. While insurance companies do not tend to say this, as they would like to protect the rest of their defendants, if they do say this, it will mean you can never sue the insurance company or defendant again. If you have been involved in a car accident and someone was injured or your vehicle was damaged, you should consider hiring a lawyer.